Declaring one's nationality shouldn't be so hard, but sometimes it is. Here we are today, ladies and gentlemen, Prince L with Moorish Temple Light Trust Corps, bringing you a video on how to declare and proclaim your nationality. For starters, this information is for informational and educational purposes only, serving as a tool, a free service to the public of individuals interested in declaring and proclaiming their nationality and administering an administrative process in conjunction with more or less the allodial process that has already been utilized in the past. So, reading from RV Bay's site, and to which I do not have any rights to the information on the site. If you have questions about the information on the sites that I list here in this video, please contact the site owner, RV Bay Publications and a few others. All right, we're going to go through quite a few. I am not a lawyer. This is not legal advice. If you need a lawyer, get one. And if you refuse to get a lawyer, then that's, it's because you feel competent enough to do what you're doing. In any case, moving right along, let's jump into this, understanding that declaring is to be clear yourself and does not necessarily require any paperwork, but does require study to be clear yourself, as you can only be what you know. You can only be what you know. Proclaiming is the publishing, and that is where the paperwork comes in. Anything in written form is but a brief expressing your position regarding a matter, whatever that matter may be, and that includes the card itself, which is a brief and lawful claim, because you are claiming to be a Moorish or Moor American. The judicial or court method of changing one's name is merely an affirmance and aid of the common law. Thus, the common law by superiority establishes supreme validation and suffices to serve public notice for declaration of a name correction and change. The court method of corroborating a name correction and change is not to be assumed as being necessary nor superior, but merely a formalized method of confirming or acknowledging a person's right to a name correction or change. Such a change carries the exact same legal weight as a court-decreed name change, as long as it is not done with fraudulent intent. All right. So if you have fraudulent intentions, you're not going to be able to get what you're looking for. For those individuals who are curious, under international law, United Nations Declaration's Rights of Indigenous People, available on the United Nations website, un.org. Up there, in accordance with Article 6, every indigenous individual has the right to a nationality. Now, for individuals who are still confused on what a nationality is, let's look at law definition on what nationals and citizens of the United States at birth are. The following shall be nationals and citizens of the United States at birth: a person born in the United States and subject to the jurisdiction thereof, a person born in the United States to a member of an Indian, Eskimo, Aleutian, or other aboriginal tribe, provided that the granting of citizenship under this subsection shall not in any manner impair or otherwise affect the right of such a person to tribal or other property. Person born outside the United States and its outlying possessions of parents, both of whom are citizens of the United States, and one of whom has a residence in the United States or one of its outlying possessions prior to the birth of such persons. A person born outside the United States and its outlying possessions of parents, one of whom is a citizen of the United States who has been physically present in the United States, or one of its outlying possessions for a continuous period of 1 year prior to the birth of such person, and the other of whom is a national but not a citizen of the United States. All right, so you see that? The other of whom is a national but not a citizen of the United States. A person born in outlying possession of the United States of parents, one of whom is a citizen of the United States, one who has been physically present in the United States, or one of its outlying possessions for a continuous period of 1 year or at any time prior to the birth of such persons. Person of unknown parentage, person born outside the geographical limits of the United States, a person born before noon outside the limits and jurisdiction of the United States of an alien father and a mother who is a citizen of the United States who prior to the birth of such person had resided in the United States. Now, let's go to definition D. A person born outside the United States and its outlying possessions of parents of whom is a citizen, of whom is a citizen of the United States who has been physically present in the United States, or one of its outlying possessions for a continuous period of 1 year prior to the birth of such person, and the other of whom is a national but not a citizen of the United States. So, a national but not a citizen. Well, is there a certain law or regulation dictating this? Why? Yes, if you review travel.state.gov's website, you'll find that the Department of State occasionally receives requests for certificates of non-citizen national status pursuant to Section 341 of the Immigration and Nationality Act. So there you go, ladies and gentlemen. Your codified law that's also codified as Title 18 USC Section 1452B. Now, if we review that section, if we go back to Cornell Law, big ups to Cornell Law, you see that we're in 8 USC Code 1401, Nationals and Citizens of the United States at birth. But let's specifically look at that portion, 302, which affects individuals of the Commonwealth of the Northern Mariana Islands in political union with the United States and for other purposes. So the INA was creating a codified or an act or engaged in an act whereby they recognized through declaration of an individual or persons born in the Northern Mariana Islands who are citizens of the Trust Territory of the Pacific Islands on the day preceding the effective date of this section, and who on that date are domiciled in the Northern Mariana Islands or in the United States or any territory thereof. But wait, there is more. As the title of the certificate indicates, only a person who is a non-citizen U.S. national, i.e. a U.S. national but not a citizen, may apply for such a certificate. As defined by the INA, all U.S. citizens are U.S. nationals, but only a relatively small number of persons acquire U.S. nationality without becoming U.S. citizens. Sections 101A21 of the INA defines the term national as a person owing permanent allegiance to a state. Owing permanent allegiance to a state. Owing permanent allegiance to the state. Section 101A22 of the INA provides that the term national of the United States includes all U.S. citizens as well as persons who, though not citizens of the United States, owe permanent allegiance to the United States. Section 308 INA confers U.S. nationality but not U.S. citizenship on persons born in an outlying possession of the United States, or both of a parent or parents who are non-citizen nationals who meet certain physical presence or residence requirements. The term outlying possession of the United States is defined in Section 101A29 of the American Samoa and Swains Island. No other statute defines any other territories or any of the states as outlying possessions. But if we review some of the pertinent sections, Section 341 of the INA, a person who claims to be a national but not a citizen of the United States may apply to the Secretary of the State for a certificate of non-citizen national status. Once again, that request is a person who claims to be a national but not a citizen making a request for the certificate. So the individual was already declared or proclaimed to be a national but not a citizen of the United States, and then applied for the certificate of non-citizen national status and presented proof to the satisfaction of the Secretary of the State that the applicant is a national but not a citizen of the United States. And in case of citizen, national born outside of the United States or its outlying possessions, taking and subscribing before an immigration officer within the United States or its outlying possessions. So, an immigration officer within the United States, this oath must be made. An oath must be made before an immigration officer within its outlying possessions of the United States. The term national means a person owning a permanent allegiance to a state. If you don't want to be a American national, perhaps you need to consider patriating to another nation. The term outlying possession of the United States means America, Samoa, and Swains Island, which are the Northern Mariana Islands. Section 101A36 of the INA, term state includes the District of Columbia, Puerto Rico, Guam, and the Virgin Islands of the United States. Section 308 of the Immigration and Nationality Act, unless otherwise provided in Section 301 of this title, the following shall be nationals but not citizens of the United States at birth. We've already gone through the majority of those. Person of unknown parentage, a person in an outlying possession of the United States, on or after the date of formal acquisition of such possession, a person born outside the United States and its outlying possessions of parents whom are nationals but not citizens of the United States, have had a residence in the United States or one of its outlying possessions prior to the birth of such person. A person of unknown parentage, a person born outside the United States, during which the national parent was not outside the United States, at least 5 years, which were after attaining the age of 14 years. The proviso of Section 301G shall apply to the national parent under this paragraph in the same manner as it applies to the citizen parent under that section. Here's the piece of the resistance for this full INA review. Section 302 of Public Law 94-21, which we were just looking at. Any person who becomes a citizen of the United States solely by virtue of the provision in Section 301 applying to those born in or residing in the Northern Mariana Islands may within 6 months after the effective date of that section or within 6 months after reaching the age of 18 years, whichever date is later, become a national but not a citizen of the United States, making a declaration under oath before any court established by the Constitution or laws of the United States or any other court of record in the Commonwealth in the form as follows. I, Prince Jonathan Edward O'Kell Moore, L, or L, Prince Jonathan Edward O'Kell Moore, being duly sworn, hereby declare my intention in accordance with Moor American and or Moorish American and or Aboriginal American, Indigenous American, birthright, sui juris, is my intention to be a national but not a citizen of the United States. In a court of record. That must be stated in a court of record. In accordance with Public Law 294-241, Section 302, any person who becomes a citizen of the United States solely by virtue of the provisions of Section 301 may within 6 months after the effective date of that section or within 6 months after reaching the age of 18, whichever date is later, become a national but not a citizen of the United States by making a declaration under oath before any court established by the Constitution or laws of the United States or any court of record in the Commonwealth in the form as follows. I state your name, being duly sworn, hereby declare my intention to be a national but not a citizen of the United States. All persons born in the Commonwealth on or after the effective date of this section and subject to the jurisdiction of the United States will be citizens of the United States at birth. But what if you don't want citizenship because you no longer wish to engage in the acts of citizenry, meaning engaging in the public debts or the public electoral process that exists, which doesn't really get us anywhere, but that's a discussion for another time. In any case, as has been said before, and it will probably be said again and again, the court method of corroborating a name correction and change is not to be assumed as being necessary nor superior, but merely a formalized method of confirming or acknowledging a person's right to a name correction or change. Now, presuming that the individuals that are watching this video are honorable beings and that they have done nothing wrong, which would make them scared to go and petition or inform the court to assist that individual in making a public proclamation to formally be recognized and have the public acknowledge the person's right to a name correction or change and their nationality in accordance with United Nations Declaration's rights of indigenous people, we see that an individual is entitled to a nationality. Once I can find where I put that at. So, oh, look at that. Nice little letter. But merely a formalized method of confirming or acknowledging a person's right to a name correction or change. Let me find United Nations Declaration's Rights of Indigenous People. Section 302 of Public Law 94-241. 241 should be familiar to some people. USC 42. Title 42 USC. Or Title 18 USC. I don't know. Maybe you guys do or you don't. In any case, that's a discussion for another time. Declaration's Rights of Indigenous People. Article 6, every indigenous individual has the right to a nationality. Indigenous individuals have the rights to life, physical and mental integrity, liberty, and security of person. Indigenous peoples have the collective right to live in freedom, peace, and security as distinct peoples and shall not be subjected to any act of genocide or any other act of violence, including forcibly removing children of the group to another group, human trafficking, kidnapping, forcibly moving children from out of their Moorish nationality, Moorish American nationality, into full-blown citizenship. Don't worry, your child has an age period. But let's review a few more things, and I'm gonna let you go. All right, I promise I'm gonna let you go. So, Chapter 2, Council of Courts, Section 141 to 143. This is Chapter 2, Title. This is Chapter 2 of Title 22, Section 141, regarding Council of Courts. All right. The act was repealed August 1st, 1956, for those individuals who are not engaging in some form of due diligence to just double check, whether or not the laws are still applicable or appropriate to your case. All right. Now I'm going to get back to those individuals who are honorable individuals who should not have any problems with filing a petition for adult name change or correction, because number one, the act of the truth, while C.M. Bay's book might still be on file in the rotunda in the Congressional Library, well, the act for Council of Courts, in which C.M. Bay's book or of the Moorish Zodiac Constitution is a review and excerpt of. I need individuals to be cognizant and competent and just clear on the fact that as of August 1st, 1956, repealed sections 141 to 143, effective upon a date which the President determined to be appropriate for the relinquishment of jurisdiction of the United States in Morocco. The relinquishment of jurisdiction of the United States in Morocco. Jurisdiction of the United States in Morocco was relinquished by memorandum of President Eisenhower dated September 15, 1956. Notice was given to Morocco on October 6, 1956, and all pending cases were disposed of by 1960. See Bulletin of State Department, Volume 35, 909. So, some people might interpret that to say that America was had relinquished jurisdiction of the United States, or the jurisdiction of the United States had been relinquished in Morocco. All right. Now, maybe somebody else needs to read that section with another intonation so that way I can hear what you just think you heard too. All right. But moving right along, Declaration of Nationality, or Declaration and Proclamation of Nationality. Given the fact that, for those who are not also not familiar with the Dred Scott decision, perhaps you need to consider that Dred Scott was considered a refugee in some shape, form, or fashion by the United States Congressional Courts. Well, it wasn't the Congressional Court, but it was a federal district court. All right. And, fact check that. But consider that Dred Scott was identified specifically, more or less, as a refugee. And so any refugees, well, let me just read it. The term refugee means A, any person who is outside any country of such person's nationality, or in the case of a person having no nationality, is outside any country in which such person last habitually resided, and who is unable or unwilling to return to, and is unable or unwilling to avail himself or herself of the protection of that country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion, or B, in such special circumstances as the President, after appropriate consultation, as defined in Section 207E of this Act, may specify any person who is within the country of such person's nationality, or in the case of a person having no nationality, within the country in which such person is habitually residing, and who is persecuted or has a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. The term refugee does not include any person who ordered, incited, assisted, or otherwise participated in the persecution of any person on account of race, religion, nationality, membership in a particular social group, or political opinion. So, in such special circumstances, as the President, after appropriate consultation, and as defined in Section 207E of this Act, may specify any person who is within the country of such person's nationality, or in the case of a person having no nationality, where they within the country in which such person is habitually residing, and who is persecuted or who has a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. So, political refugee. Political refugee without a nationality. Is it necessary for you to become a citizen? No. Perhaps you need to recognize where it is that you come from, or like if you're just awakening to the realization that you're a Moor and that you're in your homeland of origin and that there is no other place for you to be sent to, why don't you correct your name in all forms and manners possible, whether that be through the temple's application or through the court order process. Remember, you're supposed to be using 360 degrees of science. 360 degrees. If this is your system and someone else is operating your system unlawfully, or even within what other people might presume to be as fraud, but here it is that even within a fraudulent system, it still gives you the option or the capacity to act as an honorable being under duress, under coercion, forced to comply to the rules of Rome, which you reside in or domicile in order to remain honorable before the eyes of your creator and the eyes of Caesar, if you want to go there. All right? If you don't do anything Else, declare your nationality. Status is the standing, the state, or the condition being a social position. It is the legal relation of an individual to the rest of the community. Status also relates to the rights, the duties, the capacities, and the incapacities which determine a person to a given class. It is a legal relationship, not temporary in its nature, nor terminable at the mere will of the parties with which third persons and the state are concerned. While the term implies relation, it is not a mere relation. It is a legal relation, and it establishes a state, since it also signifies the condition or circumstances in which one stands in regards to his property. If North America is your property, why would you not want to establish or correct and terminate any unlawful fiduciary relationships regarding your estate and custodian and an unauthorized, unlawfully administered custodian or executorship? All right. Jurisdiction, essentially the right to adjudicate, decide regarding another jurisdiction, covers, encompasses, assimilates, and incorporates every type and kind of judicial action. Judicial actions pertain to authoritative actions and issues involving justice and the administration of justice in matters of rights of parties, rights of property, and judicial proceedings. If you have an interest in justice, do what you're supposed to do. Now, what's in a name? Not getting rid of the old name. Understand that, like in this section, just from my perspective and just from my interpretation, this is saying that, we're emphasizing that if you don't quite possibly proclaim your nationality or declare or proclaim your court order or your name change within the court of record that you use to correct or change your name with, then you are using an alias. All right? And that alias is a nom de jour. It's a fictitious name, a war name, a name assumed for a time. Therefore, what you call a birth certificate name or an era, a government name or straw or transmitting utility or slave name fits any part or all the definition of a nom de jour. It is possibly easier at first to see it is a name assumed for a time and you have decided that time is up. So if you're correcting the birth certificate name, then update your, get involved in some estate planning. Declare and state and proclaim who it is that will be the rightful heirs of your estate. In the name change process or in the name correction process, when at the point after you complete your petition for adult name correction or change, when you have your hearing date at which you will which will be post background screening for fingerprinting and any other unlawful or legal pending actions filed against you, possibly in another state or county. When you decide to go in and stand before the court magistrate or hearing officer, there will come a point where the hearing officer asks, is there anything else that you would like to say, Mr. or Mrs. L or Bay or Gay or Al or Ali, as prescribed by the Moorish Zodiac Constitution, written by C.M. Bay, on file. Moors are either L's or Bays or Gays or Alls or Alis. All right? In the hyphenated variation of El Bay or Bay El or anything else of the sort, from my recognition, appears to be in contradiction to the Moorish constitutional lawgiver, C.M. Bay. Just my perspective. I would love to hear someone else's perspective. Title 8, USC 1401, Nationals and Citizens. Familiarize yourself with it. Chapter 2, Title 22, Sections 141 to 143, to which C.M. Bay's Moorish Zodiac Constitution is written as a review of this act. aka law, because an act must be performed through executive legislation, executive and legislative. All right. You want a certificate of non-U.S. citizen nationality? Well, you can always go to the passport office with your declaration, but in your proclamation, and send that along with your DS Form 11 to the passport people, along with a payment for a fiat payment money order for the service of creating your national passport identification card and or booklet, which identifies you as a non-U.S. citizen national, to which at that point, if you want a certificate, then you could send it over to, that's right, Mike Pompeo, the Secretary of the State for the United States. Send it over there to him. Now, House Resolution 75, for those who are not familiar, this was passed in 1933, and it was passed in and for the state of Philadelphia. All right? There is a public law that references this resolution being in the congressional book. However, this is a state Republican seal. And so to be identified within Resolution 75, one would need to be either a member to a Moorish American society that was located in the city of Philadelphia. And for those individuals who are not familiar, perhaps you might want to study who those individuals were that created the Moorish American society in and of the city of Philadelphia, Pennsylvania. So, just to follow up, how to legally change someone's last name or first name or entire name, there are several reasons you may want to change your name, such as marriage, divorce, adoption, or just a desire to have a new name, or because you've spiritually evolved and, through religious customs or culture that is accustomed to you. The Bible also shows that when God, whatever name you choose to adhere or attach to, your ideal or ideology or concepts of God, God gives people new names when he gives them a new purpose. So if you feel that God gave you a new purpose, a name is a characteristic or a set of attributes, set of characteristics or properties that an individual has been endowed with, or that one's parents or one's creators would wish that that child would develop and cultivate. So spiritual and religious reasons can also be applied to reasons why you wish or an individual would want to legally change your name. All right. Obtain a name change from form specific to your state by doing a quick online search or by going to your local courthouse. Fill out the form completely, making sure to spell the new name correctly. Consider the new name carefully. Avoid names that contain profanity, hateful slurs, a celebrity's name, or copyrighted company name, as these may be rejected. So if you're curious as to why your application might get rejected, perhaps there's no unique quality to the name that you choose. All right. First names and last names can always, there are a lot of people with the same first name and the same last name, but their middle names and their middle initials can always be different. Right? Yes. Yes. Be sure if you change your name, if your name change is a result of a marriage, that the marriage certificate is filled out correctly, as the certificate can serve as your proof of name change with all institutions. Some institutions may require you to provide an actual certificate, not a photocopy. Obtain duplicate copies from your local courthouse. A divorce decree can also serve as a legal grounds to change your name without a separate court order. All right. So for women and men who are separating, you know, a man can change their name if they choose to after a decree, the same way a woman can choose to change her name at the conclusion of a divorce decree. But that's up to those consenting parties to decide for themselves. All right. Immigration and Nationality Act, estate planning, establishing who your heirs are to and who your beneficiaries will be to your estate. That's what this brief tutorial has been about. And so, I bid thee a fair farewell. Peace and love. Don't forget to like, share, comment, subscribe. If you think my information is BS, that's fine. Just articulate it intelligibly, please, and make your comments in the comment bar below. Like I shouldn't have to get secondhand information that people are banging on me. So by all means, if we're intelligent beings, we can have an intelligent discussion, and we could even set up a video where we can discuss the uses, the usages, and the applications of both ecclesiastical process and judicial process, court administration processes. All right, which hey, in the eyes of in the private and in the public, you need to be who you say you are, and that's all I got to say. Hit the subscribe button. Peace.